Okay, well, the clock has struck 12, so I figure we will get started since we only have a short half hour together. Thank you for joining us today. My name is Kaitlin Atlas, and I'm here today with Jennifer Smith and Jared Costanzo. We are all attorneys at Franczek. We are a law firm that has the privilege of representing many school districts across the state of Illinois, including many of you who are on the webinar with us today. Today, we will be discussing some special education updates, and in particular, we will be discussing the new Part 226 rules. Those are ISB's special education rules. And we are going to, while those rules cover a lot of different areas related to special education, the most recent updates really focus on changes related to meaningful participation for families of English language learners. So we're really going to delve into what those changes say and what you need to be aware of as special education administrators. Just some housekeeping items before we get started. Please do remember we have both the chat function and the Q&A function active. Feel free to submit questions throughout. We'll try and keep an eye on those as we go through. We will also save some time at the end for questions. And we do record our webinars, so as you are submitting questions, please make sure they're not about a specific student, but they are hypothetical questions, and are always statement that we have to say that this is not legal advice, this is for informational purposes only. With that, I am going to turn it over to my colleagues to talk a little bit more about the Part 226 rules.
Great, thank you, Kaitlin. Jennifer, we can go to slide 3. So what's new with the updates? The Illinois State Board of Education updated the ISB rules on special education, or Part 226, and those updates went into effect in February 2023. So what we discussed today are already in effect. The primary changes to Part 226 concern changes regarding translation and interpretation services for English language learners with disabilities and their families. We will be discussing those primary changes during today's webinar, but the main takeaway from the new regulations is that schools must ensure that parents and guardians whose native language is not English can understand and meaningfully participate in their child's education and at IEP meetings through translation and interpretation services. We also wanted to briefly note that there are other changes that were made to Part 226. So we recommend that you review all of the recent changes to Part 226 and what they mean for your school. The first change we're going to cover is regarding written translations. Part 226 requires the written translation of what ISB is calling vital documents into the 10 most commonly spoken languages in Illinois, other than English. Now, the most commonly spoken languages other than English is going to be based on the most recent home language survey results. And for a given school district, any language that is spoken by more than 20 total families in that specific school district. This translation requirement includes the translation of the individualized substance of documents on the vital documents list. Kaitlin, did you want to touch on this bullet point here?
Yes, I think this one is really important. And I always say when I'm presenting, many of you have heard me say this before, if you listen to one takeaway, let this be it. One of the questions I've gotten on these new rules is, well, you know, ISB has the forms translated, so we'll just use the translated form and then fill in our stuff in English. That's not going to be enough. ISB is very specific in these rules that the actual substance needs to be translated. So that means the goal itself, or the present level itself, needs to be translated, not just the thing that says goal 1 or present level of performance. It's actually the stuff that you're individualizing for that student that needs to be in the native language.
Great. So now you may be wondering what these vital documents are. ISB defines vital documents as those listed on your screen here. If we can go to the next slide. They do include the IEP, the parent guardian notification of conference and conference recommendations, the notice of procedural safeguards, parent guardian consent for initial evaluation, parent consent for reevaluation, the evaluation reports, eligibility determination, manifestation determination review documents, IEP progress reports, and Medicaid consent forms. So these listed here are the vital documents. Now, the updates to Part 226 also allows parents to request translation of documents that are not on the vital documents list that we just went over, if they have a vital relationship to the child's educational planning. So parents can request translation of those documents through the same process that is identified on the notification of conference form. The updated regulations also require schools to take reasonable efforts to provide those requested translations in a timely manner. And there are some timeline restrictions that the schools will have to follow that we will get into here shortly. Now, the regulations also provide requirements on who can translate the vital documents. The regulations require that all translations be performed by competent translators who have sufficient professional training on special education terminology in the special education process, or alternatively, by an outside vendor that is commercially recognized to provide competent translation services. The regulations also allow schools to use an automated translation program or an application. However, the translation will need to be reviewed and revised as necessary by an individual that is qualified to determine the accuracy of the translation. The regulations also require that all translations must be certified to be true and accurate by the translator to the best of the translator's knowledge or ability. So the main takeaway here is that schools can't just use anyone to translate the vital documents. Individuals that translate documents must have undergone appropriate training as reflected in the regulations, or use a competent vendor. Now, if a school doesn't want to use either of those two options, it can use an automated service to translate the documents. But again, those translations will need to be reviewed by someone who is qualified to confirm the accuracy of the translation and to revise those translations as necessary.
I'm going to jump in here very quickly because I have gotten some questions. I know some of the IEP software management systems have automatic translations, which is great. You can just hit a button and they have many common languages. Just to piggyback off of what Jared said, that by itself is not going to be enough. It is a fantastic start and you should utilize that function because it's going to get you probably 80, 90, 95% of the way there, but we do still need to have someone review that. From what I've heard anecdotally, most of those programs for the more common languages, so for like Spanish, they're pretty good. And for those who review them, they review them pretty quickly and say, this looks pretty good. And they're true and accurate. For less common languages, they require a little more editing and combing through and fixing up.
And maybe that's a good point, Kaitlin, to talk about. So these are what I would call, if a district doesn't do this, let's say they don't have anyone trained to review the electronic, and the question is just, do we send it to the parent anyway, or how, do we let it linger and not do it at all because we can't comply entirely? Since this is a procedural requirement, what is your thought about how does that ultimately though result in a deprivation of FAPE, and where's our exposure here depending on how compliant we can get on these? So
and many of you have probably heard me say this before, my takeaway on this is something is better than nothing. So if you have really nobody who can verify those results, you've looked for outside providers, you've looked for inside providers, you've tried everything you could, you cannot find someone. I would rather you send the automated translation. So we have sent something, knowing that yes, there's some exposure there that we didn't fully comply with the law. I can't tell you there's absolutely no risk, but we've done something to allow the parents to understand and meaningfully participate. And I would argue in your defense that there was no denial of FAPE based on that procedural deficiency because they were still able to get that document, right? That would be my argument. Obviously, the most compliant way is to do the automated translation and have someone verify it. But I think the next best thing would be to do that automated and get it out, because something is better than nothing. I am seeing a couple of questions come in. The first question, oh, sorry, Jen, did you have something to add to that?
Oh, no, just in order to facilitate what you're suggesting, folks may want to think about scheduling annual reviews or meetings that have deadlines, eligibility meetings in some time to reschedule. So for example, if parent shows up at the meeting and says, this translation was completely incomprehensible and it made no sense, well then our best bet is to postpone the meeting, have it reviewed some more, get another copy, but all of that allows time. So when you start to push up against other procedural requirements like timelines, that's when you're caught with no good solution. So just for especially for these cases, start thinking about scheduling them a little bit earlier than your actual deadline.
Yeah, this is definitely going to require us to build in a little bit of cushion time, because it is going to take some time to do this translation, forgetting the logistics of finding someone, then actually going through the document, all of that on top of, it takes some time to just do this in English to begin with. So we're adding a whole other layer.
Right.
One of the questions is, who is going to reinforce the language option in each school district? I believe the question is intended to ask, like, who's going to tell parents they have this right and make sure parents are provided with translation if necessary. This is going to be built into the notification of conference process, and on your forms it will be offered. So that, I believe, ISB will, if it hasn't already, updated its model notices, and typically your IEP software management systems follow shortly thereafter, but make sure you're checking on that so your district is up to date. The next question is, when you say we need translation, if we have more than 20 students in a building with the same language, is that based on the home language survey? Yes. So you'll need to look at your district specifically. In addition to the state most common languages, you'll need to look at your district and whether there are more than 20 families in your district who speak a common language. Where do we find the 10 most common languages? That's a really interesting question, and we were actually digging for that this morning. There is a report that's a couple years old on ISB's website. I think we have someone from ISB on the webinar today, so I don't know if they're able to share the most recent link with us, but ISB does have that information, and we can track it down for you after this if you'd like. It was actually, the one that's a couple years old was very interesting to see the vast diversity of languages that are spoken in our state. Obviously, there are some where, you know, you have one or two individuals in the whole state, or in the whole state in schools, who are speaking a particular language, and then you have some where there are thousands of individuals. But it was really remarkable to see the number of languages spoken across the state. Any updates from ISB on the qualified interpreter training? Jennifer, any updates that you're aware of? I am not aware of any updates.
I don't have an update either. Good question though.
The next question from an anonymous attendee, and I thought this would be the first question actually, is, does the 3-day draft copies require translation? So those 3-day drafts that we are required to send to parents 3 days in advance of an IEP meeting or an evaluation meeting require translation.
So I will take the aggressive position, Kaitlin, and then you can counter me a little bit.
Okay.
So if we go back to the slide, I can actually probably do that, where Jared reviewed the vital documents. And a draft IEP is not an IEP. And no one would argue that it is. It has no effect. It just isn't an IEP. It's a different document. And so I would argue that a draft IEP is not on the vital document list and is not subject to these requirements. Now, even if these procedural requirements don't apply, we do have a parent participation requirement. So if the parent says, well, I can't participate because I didn't get the draft translated. And for me specifically, having that draft translated is important to my ability to participate. Then we're in trouble. And that's where I want to be able to reschedule. Kaitlin, there's probably an argument that you always have to do it. And maybe this is one thing that's just not going to be clear until we get some more guidance or decisions. What do you think?
I think if you can, it's certainly not going to hurt you. And it's probably a best practice. So if there is a way to do it, I'm all for it. And maybe that is where we use that automated software. And we know that maybe it's not, the highest quality verified translation, but we've given something. So that would be my advice, would say, if we can, great. I agree with Jennifer that it probably doesn't strictly meet the definition of a vital document, but I would say let's try our very best to see what we can do to get something to the parent that enables them to meaningfully participate, to minimize our exposure on other fronts, not necessarily under these regs. There was a follow-up question on whether the 20 students with the same language is within a school building or within the district. So for these regulations, the way they read, the definition of common languages for a particular district is, for a given school district, any language that is spoken by more than 20 total families in that school district. Now, the person who wrote this question said the bilingual program rules are by building. So that's unfortunately just one of the areas where sometimes rules on one area don't necessarily line up with another, but that's what these rules for part 226 say. All right, if we do not have 20, do we have to provide it if parents ask for it? I'm going to hit pause on that question because I think we're going to get to it when we talk about less common languages.
Is this where Jared, you're on mute. Is this where you want to start, or did I mess up?
This is perfect. So the regulations do create some timelines that schools should be aware of, the when. For the notice of conference recommendations form and the other applicable elements of the IEP forms, translations must be provided simultaneously with English IEP documents. The regulations also note that if an IEP contains a proposal or refuse to initiate or change the educational placement of the child, the conference recommendations must be provided in writing in the preferred language of the parent or other mode of communication used by the parent. So for example, if a parent is illiterate, schools will be required to provide the conference recommendations orally. The regulations require schools to use all reasonable efforts to provide the IEP within 7 school days after the IEP meeting or as soon as possible thereafter. And all other vital IEP documents must be translated and provided to parents as soon as practicable, but not more than 30 school days after the IEP meeting. So within 30 days of the IEP meeting, schools will be required to provide a translation of those other vital IEP documents.
On this one, Jared, I would strongly encourage people, they have, if I go back to the vital document list, they have manifestation determination review documents as being something separate from IEPs. If you don't provide that translated until 30 days, and then there's as we know, challenges to that need to be expedited. So I would, even though they break it out differently, so arguably IEP and MDR paperwork are 2 different things, I would strongly encourage a very prompt translation of MDR documents, just for practical things, and not to get into a vortex where you're arguing about if the 30 days matter to their right to file and whether it's expedited or not. It just seems like an avoidable issue.
I'll piggyback off of that and offer an opinion where one was not requested. These regulations really only speak to special education and the special ed process. I do wonder whether the next wave of regulations may relate to limited English proficient families and disciplinary processes. Generally.
Well, I mean, Kaitlin, the way how broad the non-vital document language is, I think there's an argument that even under this, things like the suspension notice, the expulsion notice, those type of notices, because there's special education implications, could be considered documents, though not vital, are required to be translated under this. I think we have to be a little bit careful there. And, you know, or if we bring in other academic things that aren't from our special ed world, but we're using them in the IEP meeting, any of that, you know, we should consider whether it makes sense to translate.
What about for, I think for the next wave, like for general education students though? I mean, just general education, student discipline, we're having an expulsion hearing.
Yeah, I mean, they're gonna, I don't think they have any right to that currently, other than like maybe a constitutional or due process, you know, type argument. But you could see it coming, right, in these documents. And if you have a contested case, it would make sense to maybe use some of these as best practices in other areas. I agree. Have I totally messed us up? Sorry, Jared. Here we go.
I'm going to hand this over to Kaitlin now to discuss more about qualified interpreters.
All right. Well, I'm just going to give a brief update on qualified interpreters because as everybody knows, I'm in this vortex of like pre and post COVID, but at some point there were changes made to Part 226 that required qualified interpreters at IEP meetings upon request. And the idea was to promote meaningful participation for non-English proficient parents, right? So that they could understand what was happening in an IEP meeting. Along with all of these changes relative to the translation of documents, there were also updates made relative to the qualified interpreters. And Jennifer, if you could just jump for me. So what some of those updates were, and I'm not going to go into every single one, but some were that all interpreters for the common languages, so what we talked about before as defined as common languages, those top 10 in the state, and then any in your district where 20 or more families speak that language, along with American Sign Language, shall be qualified. I'm sorry, it's 5 most commonly spoken languages in the state of Illinois, and then for any given 20 in any given school district. And then they clarified that if a qualified interpreter is not available, we can use an outside vendor, including telephonic interpreters, provided that they are competent.
So a tip here, and I know everyone has their own practical ways of approaching these IEP meetings, but if you have a phone translator, it is just critical to have the team ready to be as concise as possible, and maybe even have one-on-one conversations with the parents to prepare, not pre-decide certain issues, because otherwise you will never get through these meetings and you spend your time on issues that are not what needs to really be discussed with the parent. We want to save, when we have that interpreter, really talk about the core issues with the student and not just, you know, be reading reports or things that could have been provided and explained in advance. So that is my tip, is usually I'm telling teams, you know, let's say it in like one sentence and prepare ahead. So that one sentence is the key thing that you need to share. Let that be translated and just allow ourselves the time and space to get through the meeting.
That is, while it sounds like a very easy takeaway, probably the hardest thing. I have sat in several interpreted meetings recently, and it is very, very difficult. So pre-meetings, are really important for interpreted meetings to really distill the message as much as we can. So this gets back to one of the questions that was asked earlier. For less common languages that do not meet that definition of common languages, the school district has to make all reasonable efforts to provide an interpreter. So what is a reasonable effort? We have to find someone who is demonstrably qualified and competent to interpret, who's trained in providing interpretations, and who's trained in the ethics. That includes using outside vendors that are telephonic, that are commercially recognized, and that can provide competent interpretation. So it's a slightly lower standard to try to make it a little easier, with the knowledge that for some of these less common languages, it may be a little more difficult to find a qualified interpreter as defined by law.
Well, and Kaitlin, I think the key thing too here is the all reasonable efforts. So that we're documenting, you know, we checked with X, Y, and Z agency, we reviewed all internal candidates, no one had the language skills or whatever. We checked with this other, you know, maybe we called ISB to see if they had any ideas. We want some sort of documentation of list of our efforts, even if those efforts are not ultimately fruitful. And then we try to, again, go back to, even if we don't have someone who meets the standard, how can we ensure understanding between us and the parents, even if it's not reached through a qualified person under these rules?
I also wanted to address one of the questions that came in. What about Section 504? So interestingly, I don't believe that these Part 226 rules specifically address Section 504. However, there was other legislation introduced last summer in the form of statutes, so laws as opposed to regulations, that specifically expanded the requirement as far as interpretation services to include 504 meetings. So parents who are deaf or do not communicate in English should have the right to an interpreter at 504 meetings. So as Jared mentioned at the beginning of our session today, there were some other changes as part of Part 226. So there were significant changes to the definition of qualified interpreter. So when those first came out, I know we were in several in-services together about what does it mean, and there were specifics about like what did you need to get on your AP language exam back when you were in high school, which always made me laugh because, like, yes, I got a 4 on the AP Spanish exam 20 years ago, but who really cares? That doesn't mean I can interpret an IEP meeting today. But nevertheless, they made pretty significant changes to that section. Rather than going into the nitty-gritty detail today, we recommend that you go into the actual changes in the regulations and look at them, because it will require a pretty careful analysis for each individual to determine whether they meet the definition of a qualified interpreter. There are some new data reporting requirements as well in terms of how many parents requested interpretation services, and ISB will be kind of generating statewide data as I understand it. And then this was more of a clarification in my opinion rather than a new substantive obligation, but there is language that clarified that parents do have rights if they believe that their requests were denied relative to interpretation or translation. So they have rights under the Individuals with Disabilities in Education Act, they have rights under Article 14 of the School Code, and they potentially have rights with the Office for Civil Rights and Disability Discrimination, race discrimination, national origin discrimination, depending on the nature of what their complaint would be.
Kaitlin, I think it's important to mention these cases are once we get to the point of a due process complaint, though, they're very fact specific, and we've seen decisions go both ways. For example, you know, both cases could be where parents said, I wasn't provided an interpreter or a translation, but then the question somewhat becomes, okay, but then what did the parent understand, and were they able to meaningfully participate or not? And so, and that's going to turn on, you know, things outside of your strict compliance with these rules. So I guess I just don't want everyone to panic, you know, that we're going to get a million complaints. If a parent talks to you about a concern with this, you know, you can always re-meet, you can always provide them more drafts. These things tend to be resolvable if you work with the parent and communicate about their needs. So I just wanted to mention that it's not a clear cut. These are procedural requirements that then we're just going to do our best on at every stage.
And I think you just hit it, Jennifer. It's really try your best. Where we see the cases really go awry is when we say, oh, well, we don't do that here. We don't interpret IEP meetings here, or we don't translate here. Where we see more flexibility from the courts and the agencies is when we would do something like, we're trying to find an interpreter, but for now we're trying to find a translator, but for now we are giving you this document that's been translated by this software. We know it might not be perfect, right? So what we're trying to do is document our efforts and do everything we can, even if we cannot comply, you know, to the exact letter of the law. It looks like there was one more question. I know we're a minute over. How do we note, record, or capture whether an interpreter is qualified, specifically if it is a current staff member? So I think there are actually a couple questions embedded in there. First, we should kind of have record of which of our staff members, separate from a specific meeting, do meet the qualifications to be a qualified interpreter in a specific language. That's not something we're going to do in the moment at an IEP meeting. That's something that's going to go through our staffing process, right? So have they taken the tests? Have they done the requisite trainings for both interpretation and special education terminology, all of that. So we have that documented somewhere. And then at the particular meeting in which they are interpreting, I would make sure we have in the notes, you know, Jennifer Smith served as an interpreter. She is a qualified interpreter for the Spanish language, something like that. So we have it in the notes. I know we've kept you 2 minutes over, but does anybody have any last minute lingering questions? Oh, like one came in, oops.
I think it's our trainings and tests to be a qualified interpreter available.
I believe the answer is yes, but I don't know what the status of specifically ISB's training on that is. So I think there are, you know, national and other organizations that have trainings, but I don't know about ISB specifically. I know there's a question about when this goes into effect. This is live. This went live in February 23. And then there was one question that I think we missed in here. If the district provides translation automatically, does that equate to a parental request for an interpreter? No, there's a separate, you know, process through the notice of conference process that delineates how they request an interpreter, but I would be kind of more forthcoming to just make sure we've, you know, just make sure they know, just because we've provided this to you in a translated form, you still have to tell us if you want there to be an interpreter at the meeting, right?
Right, and we need to overall keep in mind our parent participation requirements. So at the same way that not following these doesn't automatically deprive us of a FAPE, rigidly following them, but being at the table with a parent who didn't make a request, but clearly cannot participate in the meeting or understand, that's not going to be compliant either. So I think it goes both ways, that our goal is, you know, being able to communicate effectively with the parent, and that should be overriding on and not the technicalities in either direction.
Yeah, and also I have said there have been a couple of questions that I've gotten where it's a parent who clearly does not speak English, but has not requested an interpreter. My advice is have an interpreter available if we can. And if the parent says, I don't want that person here, I can speak English, I don't want, get them out of here. then we're documenting very specifically in the notes, the parent dismissed the interpreter. It was, that person was available. And I still recommend, if we can, especially if it's someone who's in your district, have them hang around so that if we need to, they can come back in pretty quickly. I know that's a large ask, but that's my recommendation. I did see one other question in here of when is the start date on this? So I just want to reiterate, these are live now. I know in some of the correspondence about this webinar, it was like new rules for 23-24 school year. I think that was just to get people's attention because we have a new school year coming up, but these are live as we speak. They are unrolled as we speak.
We did get a helpful comment from Elizabeth Degree.
Oh yeah.
That ISB expects their training to be available in the fall. So, and obviously Elizabeth's with IWSC, so that's great information. Thank you. And then this last question, I do get a lot. If a parent brings a relative or a friend to interpret, does that clear the district of providing an interpreter of their own? No, yeah, it doesn't. And also we want to be careful there. One of the last meetings I was at, there was family members who spoke the language in and out. We had a translator. Everyone started kind of arguing about the correctness of the translation. We want our own person that we can rely on as sort of the district version of the conversation. And obviously, if we're relying on a sibling or, a family member, it adds a layer that is, that we have not reliably provided what we need to under the rules. All right. Well, thank you.
Thanks, everybody. Good to see everyone.